I am not going to grant the motion to dismiss for want of speedy trial.
In evaluating the case to see if there was a possibility for a motion to suppress, I noticed that there was no body cam arrest videos on this case. And so the ADA at that time had to go to the San Antonio Police Department and request it. And it turns out that was never uploaded. So that was part of the delay.
The court is not inclined to exclude that or grant a dismissal for that one item.
If you recall, Judge, from the last setting, we were set for trial.
Mm-hmm.
We were set for a motion to suppress evidence.
Mm-hmm.
About 20 minutes before that motion to suppress evidence, I was given some records pertaining directly to that motion to suppress evidence.
Mm-hmm.
And after that, obviously, I was forced into a position where I needed to request more time to review those records to see what that was about prior to the hearing.
Yes.
And you granted a continuance. I didn't want to have to ask for it, but I was forced to in order to effectively represent my client.
If I remember correctly, I stated that neither party will be charged a motion for continuance because if I remember correctly, and I'd like to think my mind is still a steel trap, although people have been trying to gaslight me of late. But what I remember is that the state had obtained some information, and it wasn't information that it just had sitting in a file somewhere. And so it didn't seem that it was neglect on the state's part or lack of diligence on the state's part. And I know you needed more time to review. And so the court said, I'm not charging anyone with a continuance.
The only small part about that I would disagree with, Judge, is that the San Antonio Police Department is part of the state, and they've had those records since for years. For I'm not saying that this prosecutor had those records, but the San Antonio Police Department sat on those records until they were forced into this motion to suppress. And at the time, and the state had also filed their own motion for a continuance based on the unavailability of a witness.
Okay.
And now, and you admonished the parties, Judge, at the last setting, there was going to be no more continuances. This was going to be set for trial at the end of March.
Yes.
Since then, in the last 10 to 20 days before trial, we've received a tremendous amount of evidence, Judge, that's been uploaded. There's been 212 jail calls, 44 new videos, body cams, dash cams, 53 new PDF documents. And of those documents, one of them is a 571-page gunshot residue detailed lab report of the opinions set forth in the previous gunshot residue lab report. There was a Brady notice for the gunshot residue in the Bexar County Crime Lab. The letter was written from the DA's office in December of 2024. There was punishment evidence that was uploaded, all of cases that have been in the state's possession since before even this alleged offense date, as they are older files. There was a new firearms testing report that was requested by the state on the same date as the last hearing. So on February 20th, there's a submission saying that the state requested further firearms testing.
So I understand where this is going, but what are you going to be asking for?
I'm going to be asking for you to dismiss this case, Judge, based on a violation of my client's speedy trial rights. And if you let me just hash all that out.
Okay, sure. We'll go on the record.
Okay. Right. Oh, I thought we were.
No.
All right. I'm gonna have to say
no, I'm just trying to, yes, you're going to have to say all of that again. All right. Court is calling 2000. Just 1 second. Excuse me. If you all on the back row, ask the deputy to move you down to the other end, please. All right. We're going to go on the record. Court is calling 2023 CR 10004, State versus Tyler Ashball. Can I have parties announced for the record?
Megan Galloway for the state.
Nathaniel Navy for Mr. Ashball.
And are you Mr. Ashball?
Yes, Your Honor.
All right. So we are here for a motion to suppress. But defense, there is something you wanted to address before the motion to suppress. Is that correct?
That's correct, Judge. I filed a motion to dismiss the indictment for violation of my client's Sixth Amendment right to a speedy trial.
And I'm sorry, just one moment. Let me make sure I have the motion to dismiss. All right, Yaya. Oh, I'm sorry, Jenna. I can't see around this screen. Yes. And state, do you have a copy of his motion?
I do, thank you.
Well, in this case, certain things were said that were off the record so that everything can be on the record. We were here previously where the state had more evidence to tender to defense counsel. The evidence that was tendered to defense counsel, the court is finding that it wasn't a lack of diligence on this prosecutor's part. So, and when I say prosecutor's part, I mean Miss Galloway. So once that evidence was received by Miss Galloway gave it to the defense. The court did not charge either party with a continuance because the court found that neither party was technically at fault or had unclean hands. So now we're here today for a motion to suppress, but the defense is asking the court to hear a motion to dismiss for failure to provide speedy trial and defendant's alternative motion to exclude evidence for violations of 3914 of the Code of Criminal Procedure. So far what I have said, does everyone agree that that is what happened previously?
Yes, Judge.
I would just like to add a little bit of context that I did, as we did off the record, Judge. At that hearing, I received that evidence approximately 20 minutes prior to that hearing. Mm-hmm. That was evidence that was in the San Antonio Police Department's possession. They are still an arm of the state. They are still the state of Texas. So even though Ms. Galloway did not, and I'm not in any way insinuating that she did, intentionally withhold that or negligently withhold that, the effect was still that the state of Texas did not timely produce that evidence.
And the court understands that, but I just wanted the record to be clear that even though the court understands that there are certain agencies that are considered technically, as far as discovery is concerned, under the umbrella of the district attorney's office, I didn't want the record to reflect that Attorney Galloway in some way had evidence in her possession and just did not turn it over. I understand, counsel, what you're saying is that the police department or someone else had this evidence, not her having it in her possession. But I understand the rules, counsel.
I understand.
Yes. So the evidence that you're saying was turned over to you, if you want to place on the record, yes, how long the legal agencies had that evidence, you can place that on the record.
And so that evidence for that motion to suppress hearing on February 20th, that was in the San Antonio Police Department's possession since I believe the date of the offense, which is May 22nd, 2022, because it was real-time cell site location information, cell phone tracking data that was to Mr. Ashbaugh's cell phone. And so they requested that through his cell phone provider, and they had possession of that since the date of the offense, which at this point has been almost 3 years. And at the last setting, Judge, you gave me time to review that, and you admonished the parties that there would be no further continuances and that we would be proceeding the trial at the end of this month, March. However, in the month of March and in the last 10 to 20 days, I believe, I've received a tremendous amount of new discovery. And as I stated, that was 212 jail calls.
And I'm sorry, counsel, sorry to interrupt. So, so that I can take proper notes. Now, the items that were given to you on February 20th, what were those items?
So February 20th was just the real-time cell site location data, which related to the pings of Mr. Ashbaugh's cell phone and license plate reader information.
All right. And how long are you saying that the police department had that evidence?
since the date of the offense, May 22nd, 2022.
Judge, and I do have a response to that, but do you want me to wait until?
No, we'll just take everything one step at a time. So we'll start with that. So the real-time cell site data, defense, you're saying that the police department or the agency had access to that, we'll say, since May 22nd, 2022.
Yes.
And then you received it from the state on February 20th, 2025. All right, so let's start there. State, you want to address that one issue?
Yes, Judge. So regarding that cell site location data and the license plate information, that was tendered to Mr. Navy at the last setting. It is my understanding that although a detective with SAPD did receive it on the date of the offense, which is May 22nd of 2022, SAPD was not in possession of it because that detective was no longer employed with SAPD. And so once I learned of the existence of this record, I actually had to call up to the chief's office, and they were reporting to me that they weren't going to be able to retrieve it because that officer was no longer with SAPD. However, I told them that they needed to get with their IT department to get into the officer's drive to try to obtain it, but it was not. I went to look at the case file. It was not anywhere within the case file. And so ultimately, after conferring with the chief's office, they were able to retrieve it from the ether somewhere and provide it to me. As soon as I learned of that, I called Mr. Navy personally and let him know that they should be sending it to me. And then when I received it, I immediately gave it to him.
So you're saying that that first item with the real-time cell site data, that an officer retired or left the occupation and nobody had access to his data?
So that's my understanding, Judge, that it was not properly preserved, and so nobody had because it was not within the case file. I had called over to each respective unit to see if they had a case file for the case and if it was retained that way, and it was not. And so ultimately, I ended up with the chief's IT office, and that's how they were able to get into something called the H tribe and retrieve it out of there.
Okay. All right. Any response?
Yes, Judge. When I was given those records, they initiated from an email that detective sent from a government email. So this is something that never left the possession of the state. While this detective may have retired, it was on his government email. I know when I've left a job and my old email is still there, then supervisors still get and sort through any emails that I may have received. Now, if there wasn't a proper procedure to make sure that was available, that's not my client's fault. But it was all of this originated and maintained in the possession of the state. It didn't go anywhere else.
Okay. And then your next issue.
Okay. The next issue, Judge, is that in the month of March 2025, I've received a vast amount of evidence that has been previously undisclosed to me.
All right. So let's do this because I say take the easiest part first.
Right.
So one of that is jail calls.
Yes.
All right. So let's talk about the jail calls. And I'm assuming the jail calls, are these alleged to be your client's jail calls?
They are.
All right. So let's talk about jail calls.
Okay. So there's 212 jail calls by my count. That number may be off by a couple if I miscounted, but more or less 212 jail calls. Those jail calls are from the day he was arrested, which was also May 22nd, 2022, until I believe somewhere in June. But my client didn't bond out until July 14th of 2022. So I don't even know if these are the complete list of jail calls because they end at a certain date in June. But still, it's a vast number of jail calls that I would need to sort through. The state's provided. That means I assume I don't know what they may intend to use off of there. If there's anything exculpatory, anything that's not good for my client, but I would need to review those.
All right. So state, with regards to the jail calls, because it appears based upon what defense counsel has stated, that his client was released from the jail in the year of 2022.
Yes, Judge. So the calls that were retained under this defendant's SID number were from his date of arrest, his date of release. That would be May 22nd, 2022 to July 13th, 2022. And these calls had not been pulled by any other prosecutor, and they were uploaded to e-discovery on March 3rd, 2025.
All right. So what I can tell you all with regards to the jail calls, I understand that sometimes when someone's in custody, if they keep making calls on a daily basis, then you're going to receive some phone calls, well, jail calls that are given to you not immediately because they're continuing to make calls. But in this instance, what the court is going to do with regards to his jail calls is that's going to be excluded.
Well, Judge, right now I'm not asking for exclusion because, and I'm hesitant to do so, because there may be things that that corroborate the defense in those jail calls, Judge. And so it's basically, and the gist of my argument is the state has placed me in a position between a bad decision and a worse decision.
Well,
Right?
this is what I can tell you. With regards to your real-time, the cell site data location, the court is not inclined to exclude that or grant a dismissal for that one item.
But Judge, if you would let me, I guess, just
Yes.
finish the train of thought with the evidence and then argue for the motion to
Sure.
dismiss. I understand, we'll respect whatever the court's ruling is on that, but I do believe that we have some pretty compelling arguments to
All
make
right.
for you on that. If you'd let me do that rather
Yes.
than
Sure.
I guess piecemeal each piece of evidence. And so, okay, so we did the jail calls and then also 44 dash cam and or body cam videos. And obviously, I have not had time in the month of March of this year from that time to trial to review all those.
And when were those given to you?
Those were given to me sometime. All of this evidence was given sometime between 10 and 20 days prior to trial, which is tomorrow.
Okay. All right, you continue.
Okay. And then 53 new PDF documents. And of those, I've identified that those include a 571-page gunshot residue report, punishment evidence of at least 4 cases that are older than this case itself. So 4 cases that the state has had in its possession since before May 22nd of 2022. Gunshot residue Brady notice that the DA's office has had because their letter is dated in December of 2024. New firearms testing that was requested by the state on the date of the last suppression hearing. So they requested firearms retesting on February 20th of 2025. And then a new firearms report was issued in March of 2025. So probably just a few weeks later. And so I have a new firearms report. Also have new cell site location reports, not real-time cell site location, but historical cell site location. And then case overview reports pertaining to this case. So those 2 items, those reports are dated 2022. Officers wrote those in 22, and those have not been available to me until this time. I submitted my request for discovery and was very thorough in all the different types of evidence that I was included in. All these are covered by that motion, as well as punishment evidence, which I requested on that date on June 6th of 2022. So that's over 1,000 days ago. I've requested all of this evidence, and much of it has been in the state's possession for years. Now, whether it's one ADA who didn't look at it or another one, that doesn't matter to my client. The effect is we were ready to go to trial on the evidence that we had at the last setting, and then it was reset. We got ready again to go to trial on the evidence we had for this setting, and then it turns out that there's a whole swath of new evidence. And I will tell you, Judge, that one thing I appreciate about this court is we have a lot of discovery compliance dates at first, and you make sure that all the discovery has been complete. And then once you ensure that that's been done, then you set it for a plea deadline setting. And then after that, you give so after the client's had some time to determine whether he wants to accept a plea or reject a plea, then it proceeds to jury trial. I should be spending this time before the jury trial, preparing for the jury trial, not reviewing new evidence. And so it's undeniable at this point that Mr. Ashbaugh has made decisions on first-degree felonies, of which, if he goes to trial and loses, could potentially be spending the rest of his life in prison. He has made decisions now without knowing all the evidence that the state was going to use against him. And so at this point, Judge, there has been a violation of his speedy trial right because the prejudice to him has been so great. He's been on ankle monitor since he bonded out, which was July 14th of 2022. So he's been on ankle monitor for about 2 years and 7 months. Varying degrees of full house arrest. I believe most of the first year was just completely full house arrest. Then after that, partial house arrest after he had established a good rapport with the court that there weren't any violations. He was allowed allowances to pick up and drop off his kids, obtain work, but he's missed many opportunities for employment. He hasn't been able to plan for the future with this hanging over his head. He has 2 small children that he doesn't know if, based on what happens, he can't make plans for the future, as I stated. And so the anxiety has been extreme. He's not been able to review all of these new reports before this trial, for which we were going to be ready until we received new evidence. Every time that he meets with me, he has to request from his GPS officer to, if he can come have an attorney visit. And that's not always able to be done quickly. So he plans ahead on that. We have not had time to go sit through and go through this evidence, Judge. And so if I could now call my client as a witness, just to put on some testimony.
All right. Do you not want the state to address what you have stated so far?
It just depends on what order you'd like to structure the hearing then, Judge.
All right. State, do you want to address the issues?
Judge, so I'm going to go a little out of order, but regarding the new firearms report and defense counsel's motion, he states that the state never informed the defense that we were going to retest the firearm. That's a falsehood. I represented that to the court while Mr. Navy was standing here and his client was, that at the last setting, the person that did the initial firearms testing was no longer employed with Bexar County and that he wouldn't be available for trial until sometime in mid-April. And so I informed the court at that time that I had submitted the firearm for retesting. That way the witness would be available. And at that time, I informed the court that it would take about a minimum of 2 weeks to receive the report back. And so that's why the court gave us a 30-day reset. Regarding the 571-page detailed lab report, that's the lab discovery litigation packet. It can be turned over until they finish the firearms retesting. So that's the reason for the delay on that. Regarding the punishment evidence, I would disagree with Mr. Navy that he hasn't seen any of it because he actually represented the defendant on 2 of those cases. So he had the discovery for those. It was not uploaded in this case. However, the state's fine if the court chooses to exclude that evidence. And then the GSR Brady notice, I would argue doesn't really apply in this case. All it does is notify defense that there are questions that are asked when a GSR kit is taken. And that defense should know that if you watch his client's interview because the questions that are asked were recorded. And so that has been turned over. And regarding the dash cam video or the 44 new videos, I realized that I believe that discovery was not complete on March the 10th. And so I took it upon myself to go over to headquarters and have a meeting with the detective because I believe that there was evidence that was missing. When I first met or sat down with the detective, he informed me that he believed that those 44 videos did not exist. I told him that I believed different and that I had an obligation to turn them over if they did exist. So we sat together, we went through SAP's database, and none of those videos were preserved under the case number. And so we had to go and search through each officer individually and find the relevant video. And so that's why it was not initially turned over. Yes, it was within their possession this entire time. It just was not retained properly in the case file under the case number. And so to comply with 3914 and Heath, I did take an affirmative action to go over there and find that evidence that I believe existed and to turn it over. So I went over there on March 10th and it was turned over to Mr. Navy on March 11th.
All right. And then you wanted to call your client?
No, if I could actually respond to that, Judge.
Sure.
I don't recall Ms. Galloway saying that she was retesting the firearm. I know all of us here are the same people that were here. I don't recall that. I remember the reset reason being that that the individual who tested it would not be available, and that was the reason in the written motion. If she did say that, obviously I apologize, but I don't recall that being said at all. And if anybody else here did, then if do you recall that, Judge? I don't remember that being said.
I do.
You do?
But here's the thing. This is what I want to stress to both parties. You all both are officers of the court. The court has never had any reason to doubt your candor and honesty with the court. So I do understand, as a former defense counsel, sometimes there are a lot of cases that you have, but the court does remember Attorney Calloway stating that it was
Okay.
going to be retested
Okay.
because the person would not be available.
Well, then on that issue, I do stand corrected.
Okay.
And then, however,
But I do understand the other points that
this
that
is
you're
very
bringing up.
troubling with the other points with the San Antonio Police Department. And even if Ms. Galloway is making an effort to go inquire about evidence and retrieve it, we need to take a broad look of the length of the case. There's been multiple prosecutors that have had a hand in this case, and it doesn't matter. We don't judge it from who's the latest prosecutor on the case. We judge it as a whole. And this is still evidence that's coming in 1,000 days after I've requested it.
Mhm.
And so this is not the first time this has happened either. We've had many discovery compliance dates on this case.
Yes.
So there's been many opportunities for the state, no matter which prosecutor it's been, to get me the full discovery on this case. And here we are nearly 3 years later, and I'm getting more. I can't be confident that I have everything there is on this case just because of the pattern that's gone on, Judge. One of those discovery compliance settings was because in evaluating the case to see if there was a possibility for a motion to suppress, I noticed that there was no body cam arrest videos on this case. And so the ADA at that time had to go to the San Antonio Police Department and request it. And it turns out that was never uploaded. So that was part of the delay. And that was 30 to 40 something videos, Judge. And then obviously at the last setting, the San Antonio Police Department had not turned over everything. And then now at this setting, the San Antonio Police Department hasn't turned over everything. So where does it end, Judge? This has become a pattern on this case. And at this point, and I don't know if you want to address it bit by bit, I still have arguments to make.
Oh, no. I'll hear your arguments. Do you want to call your client?
I do, Judge. Okay.
All right. Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand, state your name for the record.
Tyler Ashbrook.
All right. Defense, you may proceed.
Thank you, Judge. Tyler, you were arrested on this case for this alleged offense on May 22nd of 2022. Is that correct?
Yes, I was.
Okay. And were you able to bond out immediately?
No, I was not.
How much time did you spend in custody before you were able to bond out?
A little over 2 months.
Okay. And when you did bond out, what was your condition of bond?
No firearms and full GPS house arrest.
Okay, full GPS house arrest.
I wasn't able to get work or employment at all whatsoever.
And so have you had an ankle monitor on you continuously since that date?
Yes, I have.
Okay. And you were on full house arrest for a significant period of time, correct?
Yes.
You were not able to work?
No, I wasn't able to work.
Okay, you were stuck at home?
Yes.
Okay, you were unable to pick up and drop off your kids?
Yes, I've also been unable to find they've also did not renew my lease because of this case as well.
Okay, so you lost your lease in your apartment because...
The home that I kept my daughter in.
Okay. And so because of that, you were forced to move in with others?
Yes.
Okay, who else? Who did you move in with?
I moved in with my parents.
Okay. And was your GPS altered at some point to include the ability to seek work?
Yes, it was.
Okay. However, can you describe the difficulties you faced in seeking stable employment.
Yes, I tried to obtain work multiple times at multiple different places and got very far up until the point where the background check came.